All right, welcome to Senate Judiciary. We'll be considering two bills today, House Bill 2.
Roll call.
Yeah, let's do a roll call.
Senator Kriegel,
Here.
Senator Crum,
Excused.
Senator Hicks,
Excused.
Senator Kolb,
Present.
Chairman Olson.
Here.
You have a quorum.
All right. We will be looking at two House bills today, House Bill 207 and House Bill 125. I believe we're doing House Bill 207 first. And we have, it is Representative Washit Day in Senate Judiciary. Welcome, Representative Washit.
Thank you, Mr. Chairman. Glad to be here. I have for you today House Bill 207, the Religious Freedom Restoration Act. Just to give you a little background on why a RFRA law, as we call it, is needed. This law simply takes us back to a standard that was in place in our country for decades of strict scrutiny when it came to governmental interference with religious freedom. And I'm always reminded that when we look at our Constitution, we have a preamble and a Article 1, Section 18 within our Constitution that highlight the importance of religious liberty in our state. So the U.S. Supreme Court changed the standard in a court case in 1990 and moved us to a lower standard of proof from the strict scrutiny standard that had preceded it. And that caused the United States Congress to promptly pass a Religious Freedom Restoration Act in 1993, and the hope was that that had solved the issue. That bill had strong bipartisan support and was signed into law by the president, who was the former governor of Arkansas. It had support from both sides of the aisle, and we had hoped, like I said, that was the end of the issue. Unfortunately, a subsequent Supreme Court case ruled that that law only applied to federal cases and did not apply to the states. So the states began a process of passing their own RFRA laws. Today, I think it's 28 states that have passed their own RFRA laws that took their standard back to the strict scrutiny standard. So strict scrutiny requires that when government's going to infringe on someone's religious freedom, there must be a compelling governmental interest. And if there is a compelling governmental interest, then the government must use the least restrictive means that achieves that compelling state interest. So the RFRA law that's proposed before you today protects every person against state action that infringes upon their religious practices. This gives every person in our state a day in court, and that guarantees that if state action has imposed an infringement on their religious freedom, that they're going to have that day in court and they're going to have a fair opportunity to argue their case. So with the 28 states, including our neighbors to the north and east and west, and in fact, both states to the east have passed RFRA laws in the last few years. But this is not the first effort that we've had to pass a RFRA law. I brought one a couple of times in the past. It just ran out of time. It wasn't anything with the issue of the bill itself, but with just the volume of legislation that we were dealing with in those years. But the very first effort to pass a RFRA law came a decade ago. Then Representative Nathan Winter brought a bill, and it flew through the House and ran into a timeline issue on the Senate end. So we bring this law now because we've started to see the Wyoming courts reference the lower standard below strict scrutiny in some of their decisions. And so it's not like this isn't happening in Wyoming. We're seeing courts apply the general interest type of standard as opposed to strict scrutiny. And so now's the time. It's the right time. We probably should have done it several years ago, but it's certainly the right time today to get a RFRA law and to join the other 28 states that have RFRA laws. So I have with me today some legal experts, some folks with a great deal of legal expertise who will certainly be able to field the more technical legal questions if there are any. And with that, I'll stand for questions.
Committee questions for Representative Washut? Representative Washut, you said there were numerous states that have passed RFRAs. Does this bill come from a particular state that it's modeled after?
It's an amalgam of legislation from a number of different states, bringing together some of the best language that we could assemble.
Senator Crago?
Thank you, Mr. Chairman. So thank you for bringing the bill, Representative Washut. One question I had, and this is in relation to a lot of discussion we've been having on the floor over the last week or two, is on the enforcement mechanism, which is at the very bottom of page 5 and the top of page 6. My question to you is, how important is the cost and attorney's fees provision to the rest of the bill? Because I know that's one of the very first questions we're gonna get on our end in particular, and we've been having this discussion about lots and lots of bills. And so the reason I'm asking that is this is an important issue to me. I want it to keep moving forward, but I don't want it to get held up by that if we don't have to.
Representative Washut?
Thank you, Mr. Chairman, Senator Crago. I think it's an important part of the bill to ensure that all persons have an opportunity to litigate their religious interests, and sometimes the ability to reclaim attorney's fees and so forth is, that can be a major obstacle for some people. So my preference would certainly be that we would preserve it. But if it were to be amended out, I don't think that it's a complete showstopper, but it is, I think, when we think about the types of folks who might be most likely to need to file a RFRA claim, they may be in the least position to personally finance litigation. And so I think having that language provided in here at least assists in that direction.
Yeah, I think it's definitely a policy decision. I mean, we operate under the American rule where each party pays their own way through litigation. That's kind of the golden rule in American jurisprudence. And when it comes to attorney's fees, and then they can be granted by statute, obviously, which is what this is attempting to do. I think our concern is just that you have to be very cautious and sparing when awarding attorney's fees by statute. And we've seen a lot of bills this session attempting to add attorney's fees by statute, and at some point it eviscerates the American rule if every statute allows for it.
Mr. Chairman, I would agree with that. And I recognize that we have seen a lot of bills this session that included this option and so forth. Perhaps our witnesses who will follow me will be able to tell you about any particular experiences in other states with that regard.
Okay. I find the state action definition interesting. I understand why it's defined the way it is because of the way that it's used in 9-25103A. But it's interesting to say that a state action is anything by the state, and anything by a local government is also a state action. And it's really not a state action. It's kind of a confusing definition. Did that come from a particular model that you were looking at?
It came from practical experience in other states where if you are too narrow in your definition of what type of governmental actions are going to be applied, then you exclude certain types of litigation. And so state action was seen as the preferred verbiage given the experience in other states.
And what you just said actually makes more sense. You said governmental action. Is there a reason, does it have to say state action, or could it be a governmental action? To me, that makes more sense because we're talking about all of these different levels of government.
I think my witnesses might be able to speak better to that question. I think it's a fair question, but I think they'll be able to answer it more articulate than I could.
Okay. Any other questions for Representative Washit? All right. Do we have any agencies wishing to testify on this bill? We didn't have any agencies sign up online, Pierre, did we? Okay. Then we'll move into general public comment. Anyone wishing to testify on this bill? Welcome. Whoever wants to go first can go. I don't have a preference.
Yeah, why don't you go first? Good afternoon, Mr. Chair, members of the committee. My name is Matt Sharp. I serve as senior counsel with Alliance Defending Freedom. Every day, people of faith serve their neighbors, offering food, clothing, shelter, and other social services. They provide jobs for thousands, and this economic benefit of religion was recently valued at $1.2 trillion annually in the United States. But the real impact is the countless lives that are forever changed by a helping hand from the faith communities. But religion's vast benefits to Wyoming will only last so long as people of faith maintain the freedom to exercise religion, not just in their home or place of worship, but in the wider community. House Bill 207 will safeguard every person's ability to peacefully live, work, and act consistent with their beliefs, even when those beliefs might be politically unpopular. This bill gives those burdened by the weight of intrusive government regulations a judicial forum where their voice can be heard and relief can be sought. House Bill 207 doesn't determine winners or losers, nor does it mean that religion always prevails. It simply protects the process by balancing the government's interest with the individual's freedom. Notably, the test employed in HB 207 is the exact same test that the Wyoming Supreme Court uses when evaluating free speech claims. So this bill simply ensures that religion receives the same level of legal protection as speech. Congress first enacted laws like this over 30 years ago. As we heard, over 28 states have done this, both blue states like Connecticut, Illinois, Rhode Island, red states, Florida, South Dakota, and Montana. And in those over 24 states, there are two interesting data points worth contemplating. First, the economies in these states are flourishing. If you look at recent rankings of best states for business, like in Forbes, US News and World Report, Yahoo Chief Executive, you'll find that not only do most states in the top 10 of those rankings have a RFRA, but the top performing state in each of those rankings has a RFRA law. Second, we also see that courts in those states are effectively separating legitimate RFRA violations from frivolous claims. There's a recent law review article by Professor Christopher Lund, who did an in-depth analysis of federal and state RFRA laws. And he found that, contrary to claims that RFRA may be misused, it's actually used by a diverse array of religious minorities to afford focused, reasonable protections to people of faith from government-related regulations that burden their religion. To quote Professor Lund, RFRA's compelling interest test on its own rarely results in inappropriate exemptions. While academic journals and others may talk about the parade of horribles, what we see is that such hypothetical claims seem less scary because they are rarely brought and they do not win. And finally, just to address the question that came up about attorney's fees. Absolutely, within America's system and claims between private parties, the general rule is each party pays their own cost. But when it comes to fundamental freedoms, when we look at our federal constitutional rights, free speech, freedom of religion, the court precedent has long been that we do want to give the individual the ability to get attorney's fees so that they can get legal counsel to go against the federal government. So when you look at Section 1983 actions, these are lawsuits against the federal government for violations of federal constitutional rights. We've always allowed those attorney's fees because it can really make a difference, as the sponsor mentioned, for the little guy that may not have the finances to fund a litigation against a government entity that has lots of resources. And so just always make sure that the courtroom doors are open to that individual whose rights have been fundamentally violated. Thank you.
Senator Crago.
Thank you, Mr. Chairman. Thanks for being here. Thanks for all the help. So one question along those same lines. Could a person who's being aggrieved in violation of this proposed law also bring a 1983 claim at the same time?
Thank you, Mr. Chair. Thank you, Mr. Chair. Potentially, it would depend. There are some limitations, especially when it comes to religious freedom, on bringing those claims. So if there's not a federal government action, there may not be the full scope of those claims. It's one of the reasons we have RFRA in the first place is the Supreme Court precedent rolled back the federal religious liberty protections. This was in the Employment Division versus Smith case. They adopt the lower standards. That's what led to the federal RFRA, which the Supreme Court said only applies against the federal government. So what this bill does is fill that gap. At the state level, when you have a free exercise violation, can people in Wyoming have that legal remedy when it's a state action, whether it's the state government, a local governmental entity? So it fills in that gap that exists right now where you have claims against the federal government if they do something, but against the state government, there's that sort of opening that we need to fill and that RFRA really does help fill.
Senator Kolb?
Yeah, thank you, Mr. Chairman. Mr. Sharp, page 3, where we go through line 2 and so forth, A, B, C, and D, could you give me an example of what is being denied here, or examples of what these are actually talking about in real life? Thank you, Mr. Chairman.
Mr. Sharp?
Thank you. Mr. Chair, so walking through those, withholding of benefits. So this could be a situation where if the government, let's say there's a state program for funding for, well, there's a Supreme Court case. Government was giving funding for playground surfaces. This happened in Missouri, and they were allowing secular preschools to get funding for this, but they denied that benefit to a religious organization. That would be an example of withholding a benefit. So this is just making sure that religious organizations have access to those same benefits.
Senator Kolb?
Yeah, thank you, Mr. Chairman. Specifically Wyoming, specific Wyoming cases that are dealing with these things. I, don't much care about Missouri. I care about Wyoming. So we could just focus in on Wyoming and things that have happened in the state that, are require a need for these kind of clarifications with RFRA. Thank you.
Mr. Sharp?
Thank you. Mr. Chair, Senator, I don't have those at the top of my head, would be happy to collect those, but I think the goal behind this is to make sure that they don't happen, to make sure that if that circumstance happens where a religious entity or organization is discriminated against, is treated worse because of their religious status, if they are burdened, then this gives them that door opening to the court system to be able to seek relief.
Mr. Sharp, I asked Representative Washut about the state action definition. It could just be, the way this bill is drafted, in the enabling language of the statute, it says governmental actions in the enactment clause. And then in the bill, it actually says state action. Governmental action actually does make more sense to me. Would there be any harm to the bill if we changed state to governmental?
Thank you, Mr. Chairman. I don't believe so. I think the state action was just sort of a term of art that we see some courts use when talking about the state generally refers to the state and any of its political subdivisions, city counties, but I would not see any issue with replacing that with government action.
Okay. Senator Craigo and then Senator Hicks.
Thank you, Mr. Chairman. So I had another question also in that provision on page 4 there. And this could be for any of you, so and someone else can chime in too if necessary. It says state action means the implementation or application of any law. And are we talking, so just so we're clear, are we talking about that implementation or application of federal law or just state law and local government law? Mr. Sharp?
Thank you, Mr. Chair. This would be state law. If there was implementation of federal law, then that would be covered by the federal RFRA, because that would be then an action against that federal law that burdens religion in some capacity. There could be circumstances where the state is maybe taking a federal law and extending it in a way that goes outside of that, where it would be the state of Wyoming or a political subdivision implementing it in a way that burdens religion. And in those circumstances where it's going outside of maybe the plain letter of the federal law and it's the state doing its own interpretation and how it's implementing, then this could allow for that in those circumstances.
Senator Craigo?
So do we need to clarify that within the bill draft or not? I know you're following where I'm trying to get at, because that's probably a question we're going to get. Are we talking about the implementation of federal law? And I understand your example, but generally speaking, we're saying no. And I don't know how to exactly craft that language, but it's something we could think about over the next day or two if it's something we need to address, because I suspect we're going to get that question.
Application of any state law. That's what we're talking about, it's a state law. Yeah.
Mr. Chairman, I think we can
Add the word
add the
state.
word state. But I think their example is us implementing a federal law, us acting on a federal law as a state agency.
Mr. Sharp.
Yeah, and if I may, Mr. Chairman, also one of my colleagues, but let's say, for example, there was a federal program that gave grants to the states to then distribute, and the state does those in a discriminatory manner, singles out religion. In that circumstance, it would be the state implementing a federal law or a federal program, and we would want to make sure that if the state is then implementing that in a way that substantially burdens religion, discriminates against religion, that there would be protection under here. So I would be cautious to insert the word state. I think we do want to make sure that even if it's a federal law that the state is implementing in a way that discriminates against religion, that this opens the door. Because in that circumstance, the federal government would say, we didn't do anything wrong. We didn't determine how it was implemented. It was the state of Wyoming doing so. And so we want to make sure that door is open.
Senator Craigo.
Thank you, Mr. Chairman. So would that fall under the federal RFRA though?
Mr. Sharp.
Mr. Chairman, I don't believe so, because again, if it's the federal government giving a block grant to the state, and then the state distributing that, but doing so in a way that discriminates against religious groups, it wouldn't be the federal government that's done anything. It would be the state in its implementation of that block grant program that would be on the hook for discriminating against religion.
Senator Craigo.
I'm good, thank you.
Senator Hicks.
Yeah. Mr. Chairman, so I just want to be clear, and it kind of dovetails into this last discussion on page 4, line 6, where we talk about any law. And so I think you've addressed the federal law issue, and then I'm going to wrap this same question in as you go up to page 4, line 1, and we talk about person. And does this now convey, with the way this is drafted, cause of actions for people that are non-US citizens by the definition of persons? Because it's not limiting to just US citizens as a person or US corporation or a US partnership. Is there some other federal regulation? Same thing would be any law. Are we now talking about international law that may be granting grants to local governments from some different organization? And so is there something else that precludes non-citizens or non-US corporations or some other country's laws or international law to come in there and be enforced under this provision?
Mr. Sharp.
Thank you, Mr. Chair. So a couple of responses to that. Number one, this ultimately goes back to, is Wyoming or political subdivision implementing something in a way that discriminates? So if there was a circumstance where there was some international grant to the state, it all comes down to how is Wyoming, and means the implementation or application of any law by the state or political. So ultimately it comes down to, did the state do something wrong? Did the state discriminate? That's going to be the hook in all of this, regardless of where that may come from. The second, to the extent that this applies to non-citizens, I think generally the courts have held that free speech, freedom of religion does apply to non-citizens. And so to the extent that there was something, if you had a situation where, let's say a child comes here, they're not yet a US citizen, and their right to exercise their religion at school was violated. We would want to make sure that in those circumstances, that child is still protected in their religious exercise while here in the country.
Any other questions for Mr. Sharp? You have a follow-up there? Senator?
No, I understand that, but it still seems like there's something there I want to think about a little bit. So page 3, line 14, and we talk about, this is the section that defines compelling government as, means government interests of the highest order. So explain to me what that means in legal terms as the highest order.
Mr. Sharp.
Is that an art of legal construct that this has a higher bearing than what?
Mr. Sharp.
Thank you, Mr. Chairman. Yes, Senator Hicks, this is a term of art that the US Supreme Court and courts across the country have consistently used when talking about this strict scrutiny test, the test that protects free speech, protects freedom of religion under RFRA and under other fundamental rights. And essentially what it means is it can't be like a government preference. It has to be something where the government says, this is a compelling interest of the highest order. It is something that is necessary for the government to be able to function. So things like public health and safety have been held to be compelling interest. obviously things dealing with military. But then even in practical sense, there's been court cases in like the prison context that maintaining order and discipline in prisons has been held to be a compelling interest. So for example, Idaho has a law very similar to this, and there was a recent Idaho Supreme Court case where a prisoner was saying that his religion demanded that he gets to smoke tobacco. And the prison said, no, we have a tobacco-free policy here, and we have an interest in making sure it stays that way. And the Idaho Supreme Court ruled for the prison and said, yes, the prison has a compelling interest in maintaining a tobacco-free environment in the prison. So it ultimately goes back to that order, discipline, health, safety, things of the highest order that really the government needs to be able to operate and serve its citizenry appropriate. But again, there's 30 plus years of case law interpreting that and really explaining what that means.
Thank you.
Other questions from Mr. Sharp? All right, thank you. Welcome.
Oh, I had the trick microphone. My name is Lance Kinzer. I'm with First Amendment Partnership, and it's a privilege to be before this committee today. Excellent questions, and I'll try to give my 2 cents on several of them. I will say the reason I'm here from Kansas today relates to my own time as a state legislator. I served in the Kansas House for 10 years, and 6 of those I had the privilege of chairing the House Judiciary Committee, including during the time when we passed our state RFRA in Kansas in 2013. And I'll tell a quick story about why we did it in Kansas. We had a lack of clarity with respect to what standard of review applied in cases where a sincerely held religious belief had been burdened by government action. We had some older Kansas Supreme Court cases that seemed to suggest that we followed the RFRA, the strict scrutiny test that existed for decades in the federal Constitution prior to the early 90s. We also had some dicta that suggested that perhaps we'd move to the same rational basis test that the Supreme Court was now applying in a significant number of religious liberty cases. We had a woman, a Jehovah's Witness, who was a Medicaid recipient, needed an organ transplant. At that time, consistent with her religious beliefs, there were no hospitals, Medicaid recipient hospitals in Kansas who performed transplants, who could do the transplant for her, consistent with her religious beliefs around blood transfusions. She sought a waiver from Kansas Medicaid regs. It's a federal program administered at the state level, and that required her to get permission from a waiver board to go more than 50 miles outside of the state lines to receive medical care. That was denied by that board, and then there was an administrative process, a district court case, a Kansas Court of Appeals case, all that focused on the question of is she entitled to rational basis review or strict scrutiny review for her claim for a religious exemption. The good news is ultimately Mary Steinmetz won. The Kansas Court of Appeals said, we think you would have won even under the rational basis test, which is rare. But the bad news, the tragic news, was that Mary Steinmetz's medical condition had so deteriorated during the period of time that this litigation was taking place that in 2012, in the United States of America, in Kansas, Mary Steinmetz died for her sincerely held religious belief around blood transfusions because she was no longer eligible for the transplant list. Her condition had so deteriorated by the time she won her case. In 2013, in response to that and other concerns, Kansas passed our version of RFRA to make it crystal clear that where you have a circumstance where someone's religious beliefs are being burdened by a decision or action of the government, that when they get their day in court, the government simply has to do what they have to do with respect to other fundamental rights. And that is show we have a very good reason for why we're doing what we're doing, and we're using the narrowest or least restrictive means we can to achieve that government interest. That's the standard that it applied for decades at the federal level. It's the standard that applies now at the federal level because of the RFRA statute. Ironically enough, it's the statute that applies in most prisoner cases and land use cases because of the Religious Land Use Institutionalized Person Act. So we have a very narrow range of cases, and now in an actually very narrow range of states. We're up to we have 28 states that have statutory RFRAs. We have another 10 that have relatively contemporaneous state Supreme Court cases adopting the strict scrutiny standard with respect to their interpretation of their own constitution. So Wyoming is definitely an outlier with respect to not having that clarity around religious liberty. It's interesting that 7 of those 28 states, those statutory RFRA states, have passed their statutory RFRAs since 2021. And I think a lot of that is a result of the fact that in the context of COVID, there was a recognition, even in states that didn't have particular problems of significant government overreach, but there was a recognition that oftentimes it is state government action or local government action that most impacts the ability of people to live out their faith. And so we have 7 states, Montana, North Dakota, South Dakota, West Virginia, Iowa, Nebraska, Utah, who've all passed state RFRAs since 2021. It was mentioned, I think, in the representative's introduction, in many of those instances, the support has been bipartisan. Nebraska unicameral passed their RFRA 39-0. In Utah, it was passed unanimously through both chambers. And I think there's a recognition that that there's just something a bit out of whack when this very normal course, strict scrutiny standard that traditionally has been applied to the adjudication of fundamental rights has this kind of carve out with respect to some types of state and local government action around the issue of religious liberty. My feeling on some of the questions that have been asked is with respect to attorney's fees, and certainly not that this necessarily matters, but during my time chairing a state judiciary committee, I was very suspect of attorney fees provisions, generally speaking, a defender of the American rule. I was a civil litigator prior to doing this work. I do think that if there's ever a case where you're going to allow for an attorney's fee provision, it is almost traditional within the American system to carve out circumstances where there's litigation over fundamental rights like religious exercise or speech. And so from my perspective, that's the longstanding practice at the federal level. It's commonplace in state RFRAs to have an attorney fees provision. And so while I think it's a perfectly appropriate question and it's a policy decision for legislators to make in every state, if there's ever a case where allowing a prevailing plaintiff to recover attorney's fees makes sense, I think it's when a fundamental right is being adjudicated. With respect to state versus government action, it would work no harm in the bill to change state to government as long as the definition of state action just became the definition of government action. There's actually, if you look at the 28 state RFRAs, there's a variety of language. As Mr. Sharp was saying, it has become somewhat commonplace in some of the case law to use kind of an expansive definition of state, to say the state just means governmental entity. But if it would add clarity, and if the legislature here would prefer, I think it would work no infirmity on the intent of the bill to use government as opposed to state. In terms of ways in which this has come up in the context of cases in Wyoming. I think a good example, at least the one Wyoming specific case that I'm aware of, I included a cite to it in my written testimony. I've got a copy of the case here. It's a U.S. District Court case, so it's a federal case, but it involved some school teachers who had an issue with Sweetwater County School Board, and they brought a number of constitutional claims in that case. And ultimately, what's interesting with respect to this is not so much the exact issues that were being adjudicated, but for our purposes, what's interesting, I think, is that as the court was going through and doing the analysis, when it got to the religious liberty claims, because their claims were under the First Amendment, because there was no state RFRA, no ability to argue for a higher Wyoming standard, those religious liberty claims, which may have lost anyway, the court would have balanced it, but they only got rational basis review given the existence of federal jurisprudence on the First Amendment, given the fact that the federal RFRA didn't apply, and given the fact that that was, the district court judge's view of what the appropriate standard was under Wyoming law. So that case, I think, and it's important to say, RFRA doesn't determine the outcome. It doesn't say whether a plaintiff wins or loses. It merely determines what standard will the court apply in doing that evaluation. And I think most lawyers would tell you that if you go into court arguing against the government with a rational basis test, the likelihood that you're going to win is extremely remote. This standard, the compelling interest test standard, again, it's a high standard for the government, but by the same token, I think when we're talking about a fundamental liberty interest, it's reasonable for the standard to be high. So I guess the way I would conclude and stand for any questions from the committee is just to say that we do have 30 plus years now of the federal RFRA. We actually have decades of case law that predate RFRA when the First Amendment was being interpreted under the standard, and we have lots of state case law. And as Mr. Sharp already suggested, I think what that case law shows is that courts all across the country at the federal and state level have been able to responsibly and effectively adjudicate religious liberty cases under this standard in a way that protects the legitimate needs of government to regulate in a whole host of areas while respecting the high standard that the Americans have always placed on free exercise of religion. And so I would encourage this committee to advance this bill, which really just establishes what I think is a very normal course kind of adjudicative rule for fundamental liberty interests like religion. So thank you so much.
When you served in the House, did you learn how to filibuster?
Oh, sorry. I apologize for the amount of time I used. I did a couple times, yes.
Senator Colby.
Yeah, thank you, Mr. Chairman. Counselor, frankly, one of your examples scares me to death. I would like to know the sideboards on this. I mean, I'm afraid the way you explained it, it's good for anything. I could be the peyote worshiping religion and it can't be denied. For folks that make decisions upon their religion, like the example you gave, that's their right to do that. However, they can't hold anyone else, compel anyone else to agree what they're saying when it becomes a strict religious interpretation of what they want to believe, and then the consequences of their action. I don't know what we're trying to say here. We want to just give in to anything. So my broad question is how far does this go? How broad does this go? I'm not hearing any sideboards. I'm hearing if it's I'm claiming a religious right, I can do anything. And I'm concerned that it's so wide, I don't understand it now. So I've got a lot more questions than I had when I started.
Well, I think that.
Thank you.
Was it
Mr.
Kinzer?
Chairman, yes.
Mr. Kinzer, go ahead.
Yes. One of the things that I think hopefully would provide some degree of solace in that regard is that courts are very good at evaluating a whole host of things under this test. And one is evaluating the existence of a sincerely held religious belief. And so it's not merely anything that someone says that they may like to do, that they would prefer to do, and then they can, kind of baptize that in religious language. Rather, courts very frequently, they typically will not inquire deeply into the nature of the belief itself. In other words, they won't say, is this a rational belief? Is this something, they won't judge it on those standards, but what they will judge it on is this a sincerely held religious belief? And there are many cases that we could talk about where where RFRA cases have been brought and courts have said, you don't get across the initial hurdle because you can't show that you have a sincerely held religious belief that's been burdened. And so you have to show government burden. You have to show that it's a religious belief that's sincere. And then having shown that, the government can still prevail by simply showing that they have a compelling reason for doing what they're doing and they're using the least restrictive means. So the test itself mitigates against its overuse. But the reality is, when we're talking about, the definition of religion, the First Amendment, the Montana Constitution, any kind of constitutional or statutory provision that deals with religious belief deals with the issue that you're talking about. And my point in that regard is that we have a lot of decades and decades of adjudicating exactly that question. And at the federal level, the existence of the RFRA, of federal RFRA with a very broad definition of religion for over 30 years hasn't led to the ability of folks to just, willy-nilly violate federal law by claiming a religious belief in a given circumstance. So the test itself and the way it's been applied, I think, mitigates against that danger.
Senator Hicks?
Yeah, thank you. It appears that you're pretty familiar with these last 7 states that have passed the legislation. So my question is obviously there's not model legislation out there, but how closely does the bill that we have before us conform with those other state laws that have been adopted to address this issue?
So what I would say.
And if I may, if there's anything that deviates, what I would say substantially or something, could you point that out if there is any deviations from what the other states have passed?
Yeah.
Mr. Kinzer?
So this is what I would say. Mr. Chairman, the core test is the same, the substantial burden test. The one thing that is, it's not that it doesn't exist in other state RFRAs, because it does, but the one thing that is a distinction, I would say, in answering your question candidly, is that in many state RFRAs and in the federal RFRA, instead of just saying burden, oftentimes it says substantial burden. And that, it's interesting because the First Amendment case law, including some relatively recent federal Court of Appeals cases, would suggest that mere burden, not substantial burden, is in fact the First Amendment test. I think the cases in which substantial would make a difference in the outcome of any case would be a very small subset of cases. And so I think there's a good argument. There are 5 states that use mere burden. There's a good argument for matching the statutory standard to the constitutional standard, which is mere burden. But if there was one thing that I think in candor you could point to and say, where does this go a little further than the statutory language of most state RFRAs and of the federal RFRA, it would be burden. And so if the committee or the legislature wanted to amend the bill so that where it talks about burden, it instead says substantial burden, I think that would be, it would be consistent with a lot of other RFRAs and the federal RFRA. And again, I think there's a very good argument for the language that's in the bill currently, but that's the one thing I would point to and wouldn't have personally an objection to including that substantial language in defining burden.
Yeah, I'm glad you mentioned that because I was curious about that when I was asking Representative Washit what this was modeled after. And the federal law and the Supreme Court interpretations have been a substantial burden is
Right.
the language they use. So I did think that was interesting. But you said it's not an issue if we include that, but I don't know what the benefit is to including substantial. Mr.
Chairman, from my perspective, it would be, it would work a minimal change in the bill to do so, but if there was a comfort level associated with matching the federal language, then I can see a benefit of doing that. And again, it's more common in state RFRAs to include substantial. It's not, there are other states that don't do that, but the majority do.
Other questions, committee? All right, Mr. Winters.
Thank you, Mr. Chairman, Committee. My name is Nathan Winters, President of the Wyoming Family Alliance. And adding on to what 2 of the foremost speakers on this subject in the United States of America have explained, I need to be very careful about what I'm trying to add to the conversation. I will give you a little bit of history regarding this particular bill in the state of Wyoming. In 2015, I invested a great amount of time on this particular bill, first time it was ever presented here. That year, actually 16 states presented it, and we made it through the House. and worked on it very hard. It was very odd. For the first time in my lifetime, I had about 750,000 people not liking me, apparently, on Twitter. By the same token, when it went over to the Senate, the then Senate president sat on it along with 16 other bills. But this has been a major issue for quite some time, and it's time for Wyoming
Tell
to
us how you
fill this
really
hole.
feel.
Oh, I'll try to make sure everybody knows. No, this is something that I love. I love elements of public policy, but sometimes the political side is intriguing. But this is an important bill. I think the following 10 years have showed why this is so important for the state of Wyoming. 28 states have this bill. Another 10 have come up with at least a strict scrutiny standard through jurisprudence. Wyoming still has this as a gap, and this is a problem. This is a well-adjudicated piece of law, and yet Wyoming doesn't have this yet, and it would help in several cases, for instance, the Rock Springs case. I do think that as we look at the law, we can't lose sight of the fact that what this is doing is saying that if there is a conflict in the law between a private individual and the government, this is why we contemplated even calling it the Government Non-Discrimination Act. But I think RFRA has such a long history, that's why we kept it. But when you look at that, it's just simply saying that there will be these guardrails. We'll say that there has to be a compelling governmental interest first. Secondly, if there is a compelling governmental interest, we will use the least restrictive means possible. I think that helps us a whole lot as we are trying to look through these kind of cases where, mind you, again, this is the First Amendment, the foundational right that we have to a free society. So if we're going to run into a challenge regarding the First Amendment, that there is something that provides the signpost to the judicial branch that helps them understand how this ought to go. I was so appreciative of Mr. Kinzer adding this. I don't think it's going to be a problem, and I even looked at this as well. I think that using the word substantial probably does help signal to other people that this is in line with a lot of the jurisprudence that's already been hammered out over the last 30 years. Rather than putting us in some sort of different category, I think it will both help clarify the bill to some and it doesn't harm the bill at all. I wanted to add this as well, because I've heard it over and again. This bill doesn't predispose one group over another. And some have argued that it might do that. They'll say that, well, people are trying to use the government to discriminate against certain people groups. That's not at all what the bill does. What this bill does is it makes sure that the government cannot discriminate against certain people groups, regardless of their background. And so I think that it protects everyone. It doesn't allow for anyone to have their fundamental freedoms infringed upon. And for that reason, Mr. Chairman, I just want to rise in support, along with all of those at Wyoming Family Alliance, in favor of this bill, one that is extremely near and dear to my heart. But with that, Mr. Chairman, I would stand for any questions.
Questions for Mr. Winters? Yes, Senator Kolb.
Yeah, thank you, Mr. Chairman. Good afternoon, Mr. Winters.
Good afternoon.
The question would be do you see any circumstances where this can be abused? Can people use this as a weapon against somebody else? I mean, you obviously are well familiar with this. I'd like to hear your opinion. Thank you, Mr. Chairman.
Mr. Winters?
Thank you. Mr. Chairman and Senator Kolb, I don't. And the reason why I believe I can say it so clearly, so plainly and passionately, is because when you look at how many of these cases have been adjudicated over the years, it doesn't automatically say that this is going to tilt toward the private individual. The government often comes out on the right side of this. It just says that if there is going to be a question, if there is going to be a conflict, we're going to use strict scrutiny. And so for that, there have been questions like, how will this be used, by a prisoner in a prison system or things like that? Those have been hammered out well over the years. I do think, by the way, that substantial helps. But no, I believe this keeps the government from being weaponized rather than weaponizes the government.
Anything else from Mr. Winters' committee? All right, thank you.
Thank you.
Ms. Burlingame, welcome.
Thank you, Mr. Chairman. Thank you, committee. My name is Sarah Burlingame. I'm the Executive Director of Wyoming Equality, and we are in mild opposition to this bill. I say we're in mild opposition because our friends at the First Amendment Foundation, I think, have done a pretty good job of lowering our temperature on it and convincing us that the courts will provide a kind of check against this. Our fear now is that over the next 4 years, the bulwark that the courts have provided as checks against unintended uses of the RFRA may change. They might shift with different judicial positions. And we weren't going to speak, I was just going to listen, but I do want to respond to Senator Kolb's question about what the guardrails are. The 4 cases that I could find that I think fall under this, if folks aren't familiar with the Satanic Temple exists as a sincerely held religious group that really works to sort of prove against these sort of bills. And in the 4 states that had successful challenges by the Satanic Temple, Oklahoma had a 10 Commandment ruling that said that the Oklahoma Supreme Court ruled that a 6-foot statue of the 10 Commandments be removed because the Satanic Temple said, hey, this doesn't reflect our sincerely held religious beliefs. An after-school Satan club in Pennsylvania, the Satanic Temple won a $200,000 settlement and the right to operate an after-school Satan club in a Pennsylvania school district. An after-school Satan club in Memphis, Tennessee, and recognition of Satanism in Kentucky. The Sober Faction and Satanic Representation Campaign successfully had Satanism recognized as a religion by the Kentucky Department of Corrections. And I would just say that Kentucky, Tennessee, Pennsylvania, and Oklahoma are all states that passed a statewide RFRA. And I don't know what their language was, how closely it matches ours or not, but I would say that there are some applications of this that folks in Wyoming might resist. And I would say closer to home, I looked, we don't have a Satanism temple membership organization in the state of Wyoming, but we certainly do have fundamentalist groups. We have fundamentalist groups who promote ideas that they are absolutely welcome to do under the freedom that we all enjoy and the cover of the First Amendment. But we do believe that RFRA gives them a little bit more access to indoctrination and to the public that we think is properly held where it is right now. And I'd stand for any questions.
Any questions for Ms. Burlingame? All right.
Thank you, committee.
Other public testimony? Online? We have, yes, please come forward. Mr. Romero Martinez, welcome.
Thank you, Mr. Chairman, members of the committee. I just wanted to stand in support of this Religious Freedom Restoration Act. It was in the 66th class of the legislature that I was the second person in Wyoming state history to bring a version of this bill. I think the conversation that is before us is long overdue. I wanted to make comment to some of the points brought forth earlier. I would be in support of the wording of government action. I also would support the concept of substantial burden, since it would be in conformity with the federal side of the House. And I wanted to just reference, I think most of you already know that the 1978 Indian Religious Freedom Act passed several years before the 1993 Religious Freedom Restoration Act. And I think what this bill does is it really just is doing what's long overdue. It's codifying statutorily what our First Amendment has promised American citizens. I think there's been mere burdens, of course, but I think there's also substantial burdens. I wanted to also just share with you briefly, and I'll yield back time because I don't have to be long-winded on this. In 2001, as an appointed member by a former senator here in the state of Wyoming to the Wyoming Advisory to the U.S. Commission on Civil Rights, I was able to meet a gentleman who was several times removed grandson of a Native American chief, and he was just talking about the importance of religious freedom. And I attended a breakout from the United States Commission of International Religious Freedom, and they just asked one question. That question was, who do you think is the most discriminated group in the world? And of course, somebody rose their hand and answered, and it was Jewish people. He actually says, no, actually, it's ancient Christians in the Holy Land and in some areas like Nigeria. Now, I know that's more of an international concern, but I think we in Wyoming set the standard here by not set, there's standards been set since the First Amendment, but we will reinforce the First Amendment standard. And I stand in support of the bill as it is written. Other than that, maybe some slight amendments to the language that I previously mentioned, and other people who could speak to the bill a lot more eloquently did previously. And I thank you for your time.
Any questions for Mr. Romero Martinez? All right, thank you for your testimony. Any other public comment? Oh, I have this online public comment. I'm sorry. Ms. Shaver, welcome.
Good afternoon, Mr. Chairman. My name is Marcy Shaver. I'm from Torrington. I am the Wyoming State Director for American Atheists, which they have statistics that show that overwhelmingly the Christian religion is favored over any other religion in these cases. Somehow the rights of minor groups are not as honored as that major religion. I had a question though for one of the gentlemen who testified earlier. This is about the attorney's fees. I just kind of wondered how much that fund takes in every year in attorney's fees cases they take on this. Anyway, I'm sort of mixed on personally on this bill because it does open up the opportunity for the satanic temple to come in and win the right to abortions for their membership. So yeah, go ahead and vote for it. Thank you. Happy to take any questions.
Any questions for Ms. Shaver? All right, thank you, Ms. Shaver. Any other public testimony online? All right, I will close public testimony. Representative Washington, did you have something else for us?
I'd just like to respond to a few of the comments and try to reassure the committee. Mr. Chairman, Senator Kolb, you know, I'd have never asked you to be a co-sponsor on this bill had the review of actual RFRA cases caused me any concern. There's over 30 years of RFRA laws in our country, and when you look at the real litigation filed under these acts across the country, under the federal RFRA or the state RFRAs, I just didn't see any of these causes of concern that sometimes come up. The cases involving the Satanic Temple, there were two of those cases I recall were free speech cases. They were not filed under RFRA. And one of those cases was dealing with a specific constitutional language dealing with expenditure of funds provision of their constitution. Again, not a RFRA case. So, you know, the Article 1 of the Wyoming State Constitution says the free exercise and enjoyment of religious profession and worship without discrimination or preference shall be forever guaranteed. Wyoming Constitution. Can that be abused? Perhaps. That's the Constitution that we have. And what this law does is simply say that we're going to use strict scrutiny as the standard when those situations arise before us. And so with that, I appreciate the committee's time, and I know we've run a little long.
All right. I'll close public comment. And committee, what is your pleasure? It's been moved by Senator Hicks on page 4, line 18. I would move to insert substantially between not and burden. I think that's consistent with the 1993 RFRA. Well, actually, it'd be more like the 2000 RFRA Act. I don't know if it was originally contained, but apparently that law was revamped in 2000 after the courts decided that didn't apply to states. What's that?
I think you have conforming amendments on 5. line 14 and 15.
And Mr. Chairman, if you're gonna do that, you probably need to go to page 2, under the definition of burden.
Okay, let's take it page by page. Page 2, burden, I don't think you have to. Burden is still, the definition of burden still remains. It's just, it's a heightened type of burden substantially.
Okay, I'm just pointing out that there's
I think that's,
things you may wanna look at.
I think that's okay. I think line 4, or 20, line 21, page 4, that's okay, because that's referring back to the burden.
Page 1, 3,
Page 1 in the title?
yes. You want to add substantial burden there.
No, I don't think you have to add it there. No, I think that's okay. But Senator Crago, page 5, a person whose exercise of religion has been substantially, that's right.
Or is likely to be substantially burdened. Next line.
So on line 15 as well, Pierre, was there any other? Correct. And I think that's it. I don't think we need to in the title. I think that's just generally referencing burden.
You want me to make that motion or?
Yeah,
I would make that motion. No, for what the chairman just did.
any discussion on this amendment?
Yeah, Mr. Chairman, I'm gonna resist this amendment. I'm just cognizant of the fact that states are sovereign and that each state writes our own state laws. And so, quite frankly, I'm very comfortable with the level of the language in here now. It may be just a little bit lower than substantial burden, but I don't feel compelled by any means to comport with what other states have done. This is our law, and quite frankly, I like to keep this existing language. It's a substantial burden.
Okay. Any other discussion? Welcome, Senator Crum.
Thank you.
All those in favor signify by saying aye.
Aye.
Any opposed?
No,
Okay, that amendment has been adopted. Do we have any other amendments, Senator Crago? No?
Mr. Chairman,
Yes.
page 6, a question of discussion on the attorney's fees. I only, a couple either striking the attorney's fees or inserting possibly reasonable attorney's fees.
no such thing.
No? Okay, then, attorneys are not reasonable. Duly
All
noted.
attorneys' fees are reasonable.
All right.
Yeah, I mean, I was thoroughly convinced by the arguments that we're dealing with a fundamental right. It's an appropriate place to provide attorney's fees. Senator Crago?
Thank you, Mr. Chairman. Yeah, I think for today, I'm fine with leaving it in. I just think we need to be prepared to have that discussion as we move forward. That was my whole point in bringing it up. Because if we take attorney's fees out, then really the only way to solve the complaint we're gonna get on the floor is to also remove compensatory damages, costs, and attorney's fees. And then you just peel it back to injunctive and declaratory relief, which is what we've been doing in some of the other bills. But I mean, as a committee, I think we just need to know we're gonna have that discussion when we take it upstairs. But I'm fine for today, just leaving it the way it is.
Mr. Chairman, just for
Senator
clarification,
Hicks.
that discussion will be attorney fees, not whether they're reasonable or not, correct?
We've agreed they're not reasonable.
I believe so.
I think that's true, yes.
All right. This bill is effective July 1, 2025. As opposed to immediately. I don't think it matters a whole lot. Okay. Anything else, committee? All right. Pierre, will you please do a roll call vote on House Bill 207, Religious Freedom Restoration Act?
Senator Crago,
Aye.
Senator Crum,
Aye.
Senator Hicks,
Aye.
Senator Kolb,
Aye.
Chairman Olson,
Aye.
5 ayes.
All right. And I believe, Senator Crago, you're floor managing this bill,
Yes, Mr.
and
Chairman,
I will be there to back you up.
thank you.
Can
And Senator Hicks is gonna die on that hill.
On a substantial hill.
Just not gonna ask that question again.
All right, welcome back, Representative Washington.
Always good before the Senate Judiciary Committee, Mr. Chairman.
We are now considering House Bill 125, repeal unauthorized use of vehicle crime. Go ahead and let us know what you have
Mr.
here.
Chairman, just for my knowledge, is there a time constraint that you all are under?
We're gaveling back, oh, I should have thought of this with you, but we're gaveling back in at 2:30. Are you guys back in at 2?
I think so.
Okay, well, we'll see what we can do.
Very good. So House Bill 125 is one of those rare bills where we're taking a statute out of the green books and not adding to it. So let me begin with a story. Late one night, you are awakened by a noise in your driveway, and you look out the window just in time to see your brand-new $65,000 pickup truck back out and disappear down the street. You grab your phone, you call the sheriff, and report your truck is stolen. A deputy responds, takes your report, begins searching for the truck, and a few minutes later, a deputy several miles away happens upon your truck being driven down the highway. He stops the truck and arrests the driver. Version 2. Late one night, you're awakened by a noise in your driveway. You look out the window just in time to see your brand-new $65,000 pickup truck sitting on blocks, and two guys are tossing the last of your 4 tires and wheels into the back of their truck and driving away down the street. You grab your phone, you call the sheriff. A deputy responds, and as she nears your subdivision, she spots the pickup with 4 tires in the back end. She pulls them over. Sure enough, they're your tires and rims, and she arrests the occupants of the truck. In version 2, the tire thieves will most likely be charged with a felony theft of property valued in excess of $1,000. In version 1, however, the truck thief will likely be charged with the misdemeanor crime of unlawful use of a motor vehicle. How in the world can stealing your tires and rims be a more serious crime than stealing the entire truck? When I presented this bill before the House committee, some of the members said, "This can't be right. You must be mistaken." Fortunately, the district attorney from my county came down and testified before and verified that my versions were accurate. And that's the purpose of this bill, is to remove 3111-102, unauthorized use of a vehicle penalty. It's important to note that this statute does not exist in the criminal codes, right? Title VI of our statutes. It's over there in the motor vehicle traffic codes, 3111. And it says any person without specific authority or of the owner or his authorized or accredited agent willfully, wantonly, or maliciously takes possession of or drives, propels, or takes away, or attempts to take possession of, drive, propel, or take away a vehicle, the property of another, for the purpose of temporarily making use of the vehicle. Temporarily. So if you're in hunting camp and somebody comes through and picks up your game rifle and disappears over the hill with it, that's a felony crime. You don't have to prove that they were just taking it temporarily. You don't have to prove they're permanently taking your rifle. Maybe they were just taking it to shoot an elk on the other side of the hill. But the fact that they took your rifle without permission makes it a felony crime. End of story. If someone takes your bull and drives away with your bull, we don't have to prove that they were permanently going to take your bull. Maybe they were just temporarily taking it down to breed some cows and they're going to bring it back when they're done. But under the statutes, the theft statutes, if you rustle somebody's livestock, you don't have to prove whether they were doing it permanently or temporarily. It's a felony crime. And so when we're talking about motor vehicles, we have this unique carve-out where the temporary taking of a vehicle, what we used to refer to as joyriding, is put in a separate statute and builds in an automatic defense for every car thief in the state of Wyoming. And I won't bore you with the vehicle theft statistics from around the state, But every year, there's a significant number of motor vehicles being stolen in our state. And the vast majority of those thieves are prosecuted with a misdemeanor crime of unlawful use of a motor vehicle. And so what this bill does, gives us an opportunity to repeal that section of statute and allow prosecutors to charge all motor vehicle thefts as thefts under the theft statute. So the question sometimes comes up, why do we have this joyriding provision? And I'm sure it dates back to the day where a couple of high school kids, your rival, and you take off with his car and park it on the other side of the school, right? And somebody said, boy, we don't want to see that kid prosecuted for a felony crime. So they created something for joyriding. Well, number one, vehicles are a little more difficult to steal today, typically, than they were back in the day. And number two, prosecutors today have a number of options at their disposal to deal with prankster-type thefts. We have a 301 deferred prosecution possibility. The prosecutor can refuse to prosecute entirely, right? Potentially, there are other tools in the toolbox today that didn't always exist. So if we were to have a prankster type theft with a lot of mitigating circumstances, our prosecutors have options. They don't have to prosecute that individual for, grand theft auto. We can charge them with other things or not charge them at all. And so with that, that's the summary of the bill. Very simple, just a complete repeal of that section of statute. With that, I'll stand for questions. Mr. Chairman.
Senator Hicks.
A couple questions. Did you get your truck back?
Just the story, not my truck.
Oh, okay, well, and then maybe I was just thinking about the example you used of borrowing somebody's rifle, and if they were just in temporary possession of that till they got it to the pawn shop, do you think we need to carve out a provision for that?
Representative Washer.
When we rewrote the theft statute, we included in there that theft of a firearm, regardless of value, is always a felony.
All right, thank you.
I'm having a slight hard time tracking why, if this statute was still in place, a prosecutor could charge a felony theft, and they can already do that now in the scenario that you gave us. They're not forced to use this misdemeanor statute. Is it, so how does repealing it actually increase the use of the felony provision or the felony theft?
Not being a prosecutor, I don't have the exact answer for that, but there was some description of a legal principle that you use the law most appropriate to the crime. And so in these cases where there isn't clear evidence that the vehicle's not in a chop shop and they're not grinding off the VIN number, there's not evidence of permanent taking, you charge the crime most applicable to the act. And then in these motor vehicle thefts, it ends up being the unlawful use statute.
So why not just make joyriding a felony and take away the temporarily part of the statute?
Mr. Chairman, it does take away the temporary language, and it gives that discretion to a prosecutor, the same way it does with the theft of every other type of property other than a vehicle presently.
Any other questions for Representative Washut? All right, thank you. Public testimony. Mr. Thompson.
The green
Glad
light was
that
already
you're-
on, so I took the middle, Mr. Chairman.
Yeah,
My name is Alan Thompson, the Executive Director of WASCOP, the Wyoming Association of Sheriffs and Chiefs of Police. Our organization looked at this concept and have pretty widespread support amongst our members to repeal for several other reasons that were already spoken today. I would like to add kind of some emphasis that we don't have any other bill in 31.5, or not bill, I'm sorry, Mr. Chairman, law in 31.5 that deals with the theft or the temporary use of property. That it seems like it should live in 6. And with the rewriting of the theft statute a few years back, prior to that time, the burden of proof for theft of a motor vehicle was with the intent to permanently deprive the owner thereof. And those were the years that I was working for a living. And in my, I guess that would have been around 20 years in law enforcement, I can only remember one instance where that was ever prosecuted as a felony. And that was because the person successfully traded it off at a dealership. I don't know how he did that, but he did that, I guess, promised a title later. And that was the one time it was ever prosecuted as a felony. So I'd just like to echo the comments from earlier, if we're stealing a firearm or a swine from somebody's yard, that's a felony. But a motor vehicle that you can't find one that runs for a value less than $1,000 now. And I would also like to point out, Mr. Chairman, that we run into the application of the theft of a motor vehicle. Oftentimes, we would, in law enforcement, investigate the damage that was attributed to the theft of the car or occurred during the theft of the car, because we would be much more successful prosecuting felony property destruction in the theft of a car than applying this. And if we just use the simple theft statute, I think it would be a easier burden to prove in that manner. And I would be happy to answer any questions if you have any, sir.
Any questions for Mr. Thompson? All right, thank you. We have public testimony online. Representative Washett, did the Prosecutors Association show up on your end of the chamber?
Mr. Chairman, my district attorney, Dan Itzen from Natrona County, came and testified before the House.
Okay.
Unable to be here today.
Okay. All right. Senator Cole?
Yeah, thank you, Mr. Chairman. I'd be more interested to hear what the county attorneys had to say. I realize, your county's one of the unique counties that has a district attorney, but I do have a question about, well, why didn't we tighten up the restrictions or the definition of joyriding, right? We say whatever, more than currently it's being, I guess, interpreted as. Why wouldn't we tighten those up instead of dropping it? I mean, why? I guess you said, I'm just asking an open question. Why do you think not trying to tighten up joyriding and being more, articulate about what it is, so we don't have the situation that we're trying to correct here by removing it? That's my question. Thank you, Mr. Chair.
Mr. Chairman, Senator Kolb, I think the better question perhaps might be, why do we not apply a joyriding type idea to any other property? Right? We don't have temporary thefts of any other property. The only one in law that we create a joyriding type exception is for motor vehicles. If you temporarily steal a television set to watch the big game, no exception, right? You temporarily take your neighbor's ride-on lawnmower and mow your back 40. It's still a theft, it's still a larceny, and we allow our prosecutors the prosecutorial discretion to then decide, based upon the facts of the case, which way to charge it.
I would bet what they had in mind was minors. I mean, that's really, I think, what you're trying to capture with the statute is the kid who temporarily takes a vehicle. You don't want to make them a felon.
Mr. Chairman, you're probably correct. But with juveniles, we're going to take those into a delinquency hearing. We're not going to prosecute them as adults, most likely for a vehicle theft.
Representative Crago?
Thank you, Mr. Chairman. So
Senator Crago.
all I was going to add is the first version of this law was passed in 1923.
Oh.
So I'm actually, between now and when we talk about it on the floor, I'll go pull the session law and see what it looks like, just out of curiosity, because I think it's probably going to be a little bit different, and the intent today might be a lot different than the intent 100 and some years ago. So it might be worthy of us all to check that out just for fun.
That sounds like so much fun. Let's do that. All right, any other questions? Senator Crum?
Mr. Chairman, my one question would be, the prosecutors have their discretion do they have the discretion to still charge with a misdemeanor, or is it discretion to prosecute felony only or let them go?
Representative Washut.
It is my understanding that they do have that discretion.
Anything else, committee? All right, thank you, Representative Washut. No public comment. I'll close public comment. We're on the bill. Committee, what is your pleasure?
Permanently move the bill.
Permanently move the bill, not temporarily.
Not temporarily, that's right.
Okay, it's been moved by Senator Kolb. Are there any amendments to this bill?
Delete the
That would be
repealer.
impossible.
Yeah, we could just start it.
Delete.
Delete the repealer.
We could make this effective immediately. I'm sure your body would concur really easily with that. And then we would turn a white bill into a colored bill.
Let's don't do that.
Question.
All right. Can you please do a roll call vote on House Bill 125?
Senator Crago,
Aye.
Senator Crum,
I,
Senator Hicks,
Aye.
Senator Kolb,
Aye.
Chairman Olson.
Aye.
5 ayes do pass.
And who's
Mr.
managing
Chairman?
this one? Is this you?
With my limited experience in jurisprudence, I think even I can probably present this bill
You
on the floor of the
sound, you
Senate.
sound perfect for this bill. All right, with that, we are adjourned.